Never mind.
Yep.
All right, good morning. It's January 21st in the Senate Judiciary. We have introductions and general overview of priorities for the upcoming session from the Judiciary, specifically Judge Zone and Perry Porcel's, the Court Administrator. So whoever would like to go first.
Come up together.
Yeah, I think that works.
Morning. Morning. For the record, I'm Tom Zone, Chief Superior Judge.
Sure, or some state court administrator.
So let me lead off for a few moments. Sure. So I'll be brief. As the members of this committee hopefully recognize, the judiciary comes in. We do have just questions sometimes that are asked by legislators, and they can happen in here. They can happen outside of here. They can happen on email or any place. And our goal is to make sure that you have the information that you need to make the policy and other decisions that you need to make on a daily basis here in the legislature. You'll often hear other stakeholders come in and say, this is what you should do, and here's why. We try to avoid getting into the policy decisions because that is where it's your job to decide what the policy is. What I do think that we try to do is work as a resource for you. We will work with ledge counsel sometimes on language for statutes to say, if this is what your policy is, here's language you might want to consider. If this is what your policy is, do you understand this is a consequence of it? Do you understand that there's been 47 states that have agreed with this or gone the other way? In other words, we'll sometimes point things like that out, but I won't say this is constitutional or this is not. We will leave that up to you, ledge counsel, and the individuals, obviously, who come in to testify on that, because it's not appropriate for a judge to prejudge or to give legal advice. I can't do that. I had a legislator once say to me, well, do you have any opinions? And then they stopped. They went, I do have opinions. You just don't tell us. And I smiled. That would be correct. But if you do have any questions, please don't hesitate to let myself or Terry know. If one of us doesn't have the answer, we get it. And that includes data. There may be data requests that you have. That's something that's a quick flip of a couple buttons. There may be data requests that are more involved, but our goal is to make sure that you get the information that you need. And there's oftentimes, we recently had some situations come up where there was a request for data points that we don't capture. And so I know that we've been talking on the judicial side about, well, maybe we should see about capturing that. Then the question is, can Odyssey, you'll hear that word, our case management system, which is now also, it's like Twitter, now called X, formerly known as Twitter, Odyssey, now known as Justice Enterprise. So you'll hear both terms interchanged. But there's some things that work well there that we can get right now. There's some things we'd have to have configurations changed. And so we look into seeing if that's something that we can do.
The other aspect of it is if there's proposed legislation, we can also comment on what the anticipated ramifications might be. For example, resource-wise or impacts on the judges or the court staff, et cetera. One example might be expungements. There are a lot of policies for expunging categories of cases, but you understand that will take five full-time persons to be able to process the expungements. That kind of aspect of it as well. So that again, we're a resource, and I apologize. I thought you had been at Legislative State in Burlington. We had like 17 legislators. So
Unfortunately, not in this stage.
Oh, okay.
Yeah.
One thing that there were new members on the House Judiciary Committee. One thing that they asked for was kind of like an overview of the court system. Didn't know if that would be helpful to you. I'm happy to.
Yeah.
This is something I sent to Kayla that the chart that just shows Vermont's unified court system, which is something that came about actually because of legislative act in 2010. Before 2010. Vermont, over the centuries, Vermont primarily had a county court system. Each county had a courthouse, and all cases were held in that, were decided in that county courthouse. And then in the 1960s, a state court was implemented, the district court that handled criminal matters. And then in the 80s, a family court, a state court system was added. And then in the 90s, environmental court, which is a statewide court in the Judicial Bureau. In 2010, there was a bill that established a unified court system and basically restructured the courts so that the county courts and the state courts became one unified court. Statewide, there is one superior court, and each county corresponds to a unit. So the superior court in Vermont has 14 units, and then in each unit there are 4 divisions: criminal, family, civil, and probate. And then the 2 statewide courts, environmental division and the judicial bureau. And the superior court is all the trial courts. That's where people come, there are witnesses, testimonies presented, the trial court has decided the case. And in Vermont, we have one level of appellate court, the Vermont Supreme Court. So if a case is appealed from the trial court, it goes straight to the Supreme Court. Some states have intermediate levels of appellate court, we just have the one. So we have also the Supreme Court, and the justices in the Supreme Court, there are 5. And the trial court judges, including Judge Zone, who's the chief superior judge, they are all appointed by the governor. And there's a judicial nominating board that includes legislators, includes lawyers, includes members of the public. They vet applicants and present a list of well-qualified applicants or nominees to the governor. The governor ultimately has the discretion to make an appointment. And you all just recently had your confirmation for the recent 4 judges who were appointed by the governor. And that would go before the full Senate then for approval. And then every 6 years, there's a retention process. And there's also a legislative retention committee that includes legislators, and you all have they named the members of that retention committee yet?
Just talking about that.
Oh,
Before I
okay.
came over here.
Okay.
We're gonna try to do it today or tomorrow.
Oh, okay. So it's staggered, but every 6 years, a judge who's been sitting on the bench and the justice go before the retention committee, and surveys are sent anonymously to people who appeared in front of that judge in the previous several years. And the retention committee receives the results of those surveys. It's litigants, it's agencies, it's public defenders, state's attorneys, anybody who's guardians ad litem. And they get those anonymous survey responses, and then they have the opportunity to question the judge for whatever shows up in the surveys. There's also a public hearing aspect of it, so that members of the public also have the opportunity to come and comment on whether or not that judge should be retained for another 6 years. So it's a measure of accountability that I think is great, that there's that opportunity for feedback. So those are again, there's the justices and the trial judges. We have 2 categories of elected judges still in Vermont: probate judges and assistant judges who are elected every 4 years on a countywide basis. So they're part of the system as well. One huge advantage of the restructuring was that the chief superior judge then has a lot more flexibility to be able to kind of move judges around where needed, so that we're all part of one system versus separate kind of county courts and state courts. And also in the mix are magistrates who are also appointed by the governor. They primarily preside in the family division here in child support cases, and then some limited jurisdiction otherwise in the family
Terry,
division. Yes,
it's a little hard to tell with the colored voting.
I know. Sorry about that.
Trying to figure out who is elected.
Oh, okay. Elected are the probate judges and the assistant judges.
I see.
Yeah.
Okay.
Those are the 2 for 4-year terms. Then assistant judges have very, very limited jurisdiction. They sit in civil and family. It's basically their kind of discretion how often they want to sit or not. They can only decide or weigh in on matters of fact, not law. And that's something that goes back to colonial times, the assistant judge role. And then the environmental division judges are 2 judges like the Superior Court judges whom the governor appoints. They primarily sit in the environmental division. Actually, you met one of the new environmental division judges, and he explained that he could also be called upon and judge so they can assign him if needed, for example, in the civil division or wherever that need might be. So it's been great to allow a lot of flexibility to try to fill gaps, and we're so excited to right now have a full complement for the first time in I don't know how long of Superior Court judges sitting. We have one retirement coming up anticipated in March, so we'll be back to having the judicial nominating board that people go to the governor, they'll come before you, but right now at present, we're fully staffed vis-a-vis the judges. The statewide judicial bureau, there's a hearing officer, who actually the chief superior judge names from applicants who are. And that person primarily in the judicial bureau hears traffic offenses and some fish and wildlife cases like that. Otherwise, in the courts, and I oversee the court staff in the state courts. There are 5 regional clerks. The state's kind of set up according to regions, although Chittenden in and of itself is one region, just because it's so voluminous. 5 regional superior court clerks, and then each courthouse each division has a court operations manager who oversees the day-to-day. And then judicial assistants are formerly known as docket clerks. They're the ones doing all the scheduling, the recording, the processing, etc. So that's kind of in a nutshell, an overview of the structure anyway, of the judiciary.
That's great.
And, oh, sorry.
I'm sorry, just judicial bureau.
Mhm.
So I'm clear on what they're off to one side, what their function is.
Primarily traffic cases. And interestingly, before the pandemic, the hearing officer would go to whatever locale where the traffic ticket was issued, for example. So there was kind of like a schedule of going to each court, and the law enforcement officers would need to go there to hear judicial bureau cases. Like so many other aspects of the judiciary, we turned to remote hearings impacting the judicial bureau, and because it proved to be so efficient, especially for law enforcement, not having to necessarily travel. It's done remotely now for all practical purposes, unless there's a reason and the hearing officer asks for in-person or law enforcement, if anybody can request in-person. But it's very convenient for litigants, for law enforcement. And the hearing officer, who happens to be from Rutland County, has a chambers there, so he conducts the hearings.
So no matter where it is in the state, the hearing officer would be in Rutland remotely with whatever law enforcement.
Right, unless someone requested it. Law enforcement,
No, to testify. Correct, and right?
they connect remotely also.
Yeah, that was my point.
We also have judges who preside. We have assistant judges who are certified, one from Orange County and one from Windham County. And so they will hear cases all over. We also have right now this probate judge who also is used as a hearing officer by special assignment. So we do that, but it is remote unless someone needs or requests to have it in person. One example of in person is we had someone said, I don't have the capacity to really be able to do this remote. What do I do? We actually made arrangements for them to be able to, it was a Northeast Kingdom, I believe. And instead of having them have to drive all the way down south, they were able to just go to a courthouse there. We had staff, they set them up in the courtroom and it was still remote, but we gave them the technology to be able to participate.
Senator Phillips.
In terms of remote participation, who ultimately makes the decision? So if a litigant says I'd prefer to be in person, can the judge just say no?
The judge has the ultimate say whether a hearing is remote or in person. But the demarcation typically is whether or not evidence is being presented. If evidence is being presented, then oftentimes it schedules an in-person hearing. But no matter what, if it's scheduled in person or remote, the litigants, the attorneys have the ability to request an alternate form of participation. And ultimately, the judge has the discretion to determine what, based on the circumstances and whether there is evidence, whatever the nature of the case is. But when there's rules that were developed that kind of give the criteria, taking into effect, distance, the reason you would be best able to speak to.
If there's, what type of case would you be?
I mean, just generally speaking,
Yeah.
I think I've certainly heard from some folks that they have made the request for in-person and been told no. And it also seems like the power differential, even asking, it could feel like, oh, I don't know if I can even ask. So I worry about people feeling like they actually don't have access.
Well, if there is a reason, for instance, if someone says, I don't have technology, I have bad bandwidth, I can't appear remotely. I would be surprised if judges are saying, no, too bad, it's a remote hearing. We can do hybrid hearings. In other words, I'm aware that oftentimes in cases, the judges provide the individuals with the discretion to decide whether they want to come in person. Domestic abuse, relief abuse proceedings are one area where if the complaining witness says, I want to be there, my understanding is that in virtually every court, okay, we'll make arrangements for that. But my understanding is that most of them feel more comfortable, individuals there not having to come to court. But in every case, if it is a remote hearing, there is the opportunity to ask the judge, can I come in person with a reason? If it's a status conference and it's remote and someone says, well, I just want to be there in person to see the other person live, judge would probably say no, that's not really a basis. But if there is any reason that it needs to be, that the judge discerns that would be a disadvantage to the party to be remote when they, after what they presented, or there's a reason to have it in person, then that does happen. Again, hybrid it's not all or nothing. You can have some people in the courtroom and some remotely. And we do hearings like that every day.
The only thing I'm trying to think under what circumstances would a judge say now. The only other thing I could think of is, one advantage of the remote versus in person, if this was perhaps a consideration, was if it's remote, you wouldn't need to have a court officer or law enforcement in the courtroom. And if they didn't have somebody scheduled, that might be a reason why the judge would say.
Or a courtroom for that matter. There are some times that we have docket, we're trying to do a lot of cases in certain courts. And if we have all the courtrooms operating, a clerk can actually sit at their desk or remotely in some courts and record. And so they could be doing it from there without having an actual courtroom. So if that docket is a civil docket of status conferences or a family docket of status conferences that is not going to have a courtroom, then that would be a reason that Terry points out the judge would say no. It's in person, but then it's remote. But then you can if the judge finds, well, yes, it would have to be remote today, but they've made a good reason why it should be in person. You just move it and have it in person on a day when you have to work.
Because I get the impression where I feel like they try to accommodate if people want to be in person.
Yes, absolutely.
Typically, but if that's an issue, I mean.
Yeah, I've just had a couple of people who have brought it up and felt like their request to be in person wasn't honored. And so I was just curious what that process looks like. And certainly people have different, interpretations of how things happen or why things happen. And so that's why I'm seeking more information.
Well, don't hesitate. If there are circumstances, feel free to reach out as we'd be happy to. Respond.
Awesome. Thank you.
I will say, just to that point, at least from what I've seen, generally speaking, it seems more so like judges will be a little more hesitant to grant access to remote hearing if there have been prior failures to appear at either remote hearings or in-person hearings. In situations where somebody has to leave the state to deal with a family health issue, or they weren't able to secure transport on that certain, or maybe a pretrial conference. I have seen them be granted for those hearings, but I think it probably does depend quite a bit on the judge and their thoughts on it. So.
Yeah, my position is that remote hearings can certainly aid us in the important work we do. They're not a substitute for everything. We have not gotten to the point, nor should we get to the point where every hearing is remote. In every docket across the board, we are a system of justice where people come into the courts. But where we have the ability to utilize the remote hearings to assist us at the right times, that is critical. You have attorneys from across the state, and I'm sure that the chair sees this in his court when he's working down. There's attorneys who may be beaming in remotely from up north because they have a conflict case they're picking up. Without the capacity to do that remotely, that person would have to drive down from, let's say, Chittenden County to Windham County. And I can assure you that I think Matt Valerio would tell you that person would not accept the case if they had to come down there all the time. And so that would leave a gap in coverage. And so we recognize there's a balance, and that's why it's important. Senator Bayowski, when you hear from people, those comments, it's critical for us to hear those comments, because if the balance isn't being met properly, we need to figure out why and what we can do to make it work.
Yeah, I've certainly heard also from a couple of I think defense attorneys, that the power dynamic feels off, that they don't even feel comfortable asking a judge because they feel like that might bias the decision against that. So I think there's maybe something in the rules committee to
I've actually been,
reconsider.
and that's a very good point, because I actually have been contacted by some defense attorneys, not on case specific, not about specific judges, but about concerns about the pressures of backlog
Mhm.
and how that can sometimes play out on the attorneys. We always talk about backlog, what are we doing, what are we doing? Well, it's a team. We have the judges, we have the staff, we have the prosecutors, and we have the defense attorneys. And if you have one prosecutor, we're loading up on them too much and they can't handle what's going on, that's not going to make them efficient to be able to address cases. It's at some point, you're gonna start having diminishing returns, because they might be able to handle 10 cases for that pre-trial day very efficiently, but they can't handle 40. And so they're probably not even going to handle 10 as well as they could if you put too many on. And so I have had contacts by attorneys about those type of concerns. I do share them with the judges during our judge meetings. That look, there are pressures out there that the attorneys sometimes feel they need to get their head up above water to breathe. So we have to recognize that.
Yeah, I was just gonna say, this is a similar conversation that we have in education with remote delivery. So during the pandemic, everybody was instructing, 100% over the internet. Now we're back to preferring in person, but there are some situations where hybrid is allowed, some situations where remote is allowed, like summer classes. But driving it all is this belief, which I share, that the in-person experience is superior. So in this case, if somebody or their lawyer wants an in-person, I hear you saying they can get it, but we're trying to be sensitive to things that might prevent them from asking. So, in both worlds, attention to the needs of the people that the system is designed to serve is the key.
And as judges, we have to be open to that.
Yeah,
That dynamic of power. I said this morning, I happened to see a couple of senators and we were laughing about the fact that they're new. And they said something about, well, yeah, I'm getting used to it. I said, well, I'm sure you became more charming and funnier the day you became a senator to a lot of people. And you get on this committee and boy, you're even funnier then. And that's what happens to judges. People don't always tell a judge no.
right.
Might I look okay? My shirt, oh, judge, it looks great. Well, it might not. The same thing, if you're sitting in a courtroom and you have a crowded courtroom and you have a staff person there and it's coming up at noon and you're supposed to take a break at noon and you want to go 5 extra minutes or 10 extra minutes, well, that's, if the judge looks at that staff member and says, we're okay to stay, aren't we? That's not equal bargaining power.
Right.
And so we recognize that. We talk to the judges about that issue. And it's the same with attorneys. Well, counsel, you can stay, can't you? And how you phrase it, how you approach it. And we on the bench have to be vigilant to make sure that we recognize that our position is something that people look up to. And we do, just sometimes by doing our job, have the potential for people to be afraid to ask questions. I remember being in courtrooms where I was afraid to ask Judge Billings something. He was a great guy, but it was like, I'm not gonna ask that.
Well, I think that's a good thing to remind when you have the judges meetings, and also for judges when they have bench bars. It's oftentimes in the counties, they'll have a bench bar for the county where they can talk about things for judges to in the county say, be sure and don't hesitate if there's reasons or in person to request it, just so they're, like you said, mindful of that.
This is one of those moments where if you ever wonder, do you make a difference? I can assure you that by 5 p.m. tonight, this message will have been discussed with all of the trial court judges because we have a meeting at 4. And so I have a list of topics that I'll go over and I'll add this to the list because I think it's a very good point.
So I know we'll be taking a deeper dive into the backlog on Thursday, but can you give us a sneak peek as to how things are improving or if they're not improving, just generally speaking?
Yeah, my understanding is number of pending cases is going down. It definitely peaked during the COVID, and then seeing that it's kind of definitely going down. There was also the glitch when we had for so many months, I think 6 million seats for judges, where so you have judges from one county have enough for another county, and both counties going to suffer as a result. But since we've had kind of those vacancies filled, and then certainly the new judge positions. And we plan to address, for example, the judge that's been dedicated to juvenile docket has already, just by scrutinizing the juvenile dockets statewide, discovered a number of cases where it was miscoded or had been miscategorized. So that, I mean, the numbers are definitely, that's been a big impact. And then the treatment court judge, Judge Griffin, who's assigned the treatment court docket, same thing. Finding and just having somebody have a dedicated eye on those cases. That's had a big impact already there. And where we had the new floating judge 2 years ago assigned to the Southern County. And one example is when they do jury draws now, they'll have the floating judge do changes of plea. Because oftentimes on a jury draw day, you might have 30 cases scheduled and, you know, you're going to draw 4 and you might have 10. That they settle, so you need a change of plea, and you have the judge right then and there to do the change of plea, instead of having to schedule it 2-3 months out for the change of plea. So steps like that will kind of go over what strategies have been employed. But my understanding is that the number of pending cases has gone down, steadily going down, and now that we have, again, the full complement, those judges are still being trained. I think they're going to be starting in February.
So they'll become operational now. Obviously, once you start, you're not going to take the same level of caseload as someone else, but we're going to have judges in all of our dockets. We should be able to have more hearings. We should be able to have more trials. What we learned in the criminal docket is that trials settle cases because when you get people together to discuss cases at pretrial, that moment, that point in time is the most critical point. That's when most of the cases will resolve or go to trial. There's the issue of being able to deliver trials is one that we've been struggling with for decades. We've never had a situation where you can have as many trials as you would need possibly. And people kind of know that. And that's why it's that pre-trial point. And if your case is put up with the front, you're going to either go to trial or resolve the case, which is what we see. And so,
Can I just for more context for the rest of the committee, when you're talking about trials or cases going up front, we've explained the trial grid and how cases are prioritized in terms of, you know, which case goes first for a jury draw.
So we have all different types of cases come in of varying severity. We have cases that will come in from unlawful trespass, retail theft, let's say. These are common crimes that you see. We have domestic assault cases. We have aggravated domestic assault cases, which could be felonies. We have sexual abuse cases, we call sexual assault cases that would commonly refer to as rape cases. We have murders. And so we have all of these different cases coming into the same court. And when a judge is at a pre-trial, you have, let's say, 100 cases, and they're all there. Which one's going to go forward first? Well, the judge and the state's attorney and defense counsel visit on things, but if all the cases are ready, the judge has to approve decisions to go through. If someone's being held without bail, under what's called 13 VSA 7553A, that means that they have to have a trial within 60 days or they have to be released from it. And so those cases come to the top of the list. And then you have individuals who have older cases. And so those cases generally come to the top of the list. So if you have an older case with an incarcerated individual, that will generally take precedence over the case where it's the same age case, but someone's not. But wait a minute. What happens if you have a newer case with somebody incarcerated that's a misdemeanor, like a domestic assault, yet you have a felony case that might be 6 or 7 months older that the person's not incarcerated, and you only have 5 trial days, and you have to figure out which case goes first. There is no right or wrong to how that's handled. And the judges work with the staff, they work with the attorneys to say, how many trial dates can we open up? Which cases are going to go forward? And it also sometimes comes down to witness availability. and things like that. And so we're trying to, when you bring these cases up, the judges have to make these difficult decisions. If you have, for instance, we engage and you be the judge. You have a day where in your community, you have someone who has 20 misdemeanor charges for retail theft and violating conditions of release because they keep going into the store and taking something. You have, by the way, 5 trial days available that month. You have a 60-day case that's going to take 2 days to domestic assault, aggravated domestic assault with a weapon. And it's going to take 2 or 3 days to try that case, and they're entitled to have that case within 60 days. You also have 2 or 3 domestic assault cases that are actually 2 years old because they have been waiting. The individuals are not in custody, but the putative victims are saying that they also have divorce cases and they want to move on with their life and they really want to go forward and they need to get this taken care of. And the defendants need to understand also what's going on there. And then you have another case where the attorney says that they're going to be going on vacation for the summer. And if you don't hear this case now in May, Judge, I don't know when we're going to be able to try it. And that case is going to be 3 days. So my question is, which cases are actually put on the list? And so those are the balance. Now, there may be a sense in the community that that individual with 20 charges, that case really needs to go. But is that more important than the 2 or 3 individuals, the victims coming, who are the putative victims in the domestic assault cases coming forward, saying that, well, our lives have been on hold for 2 years. We need this resolution. Please have this go to trial. We have minor children that are affected. We do know that the 60-day case is the one that's going to go. So those 2 days or 3 days are off. But that is the type of challenge that we face. Mm-hmm. What we also find, though, is that when we have the trial days, if we say, guess what? We now have 8 trial days. We have 9 trial days. We're probably not going to use those 8 or 9 trial days because what generally will happen is 99% of the cases either go away by dismissal or leaving. And so most cases are going to be resolved without the necessity of a trial.
But you would get that effect by promising more days, right? And then not necessarily having to use them.
It's, yes, promising and delivering.
Yeah.
If we have one of the dilemmas for case flow management is to promise or threaten something that you can't deliver, in which case everyone knows that the system has no credibility.
Right.
And so you have to maintain credibility. And so in Windham County, for instance, we were having, let's say, a week of trials. We added a week. Mm-hmm. Interestingly enough, I don't think the numbers have gone down appreciably by adding it, but it has had an impact, but not the impact that we would have had in some other counties. In some other counties, when we've added a number of trial days, the clearance rates have gone up higher because it has led to that result. But we need to do that. Mm-hmm. With the new judges we have now coming on board, my plan is to say, and actually I met with the clerks this morning and said, we're going to have more trials. We need to open up more trial days now with the judges that we have. And so we need to do that, but we need to be able to deliver.
And if I'm understanding the figures right, if 95% settle without going to trial, but they need that last spur, when you add a week, you should have a large number of cases that settle in that week.
Absolutely.
And that's what you're talking about.
Yeah.
Yeah. Okay.
Absolutely. The more trial days we have, the greater the likelihood that the parties, both sides of the equation, are going to, the state and the defense, are going to reevaluate and say, boy, we're going to really have to go to trial. The prosecutor can reevaluate and say, can I get my witnesses? How are they? Is this police officer even still employed here? Things like that come up. And then the defense can say, okay, what's it going to look like? What do we think the likelihood of success is? And then that often causes parties to reevaluate their position and come up with an agreement that maybe a month before they couldn't have achieved because they didn't have the pressure of the trial being imminent. Unfortunately, what you find is that there is a view that when you have, and I understand this view, if you have 150 people show up for a pretrial day, you have numbers like that down south, right? If 150 people show up and you have a number of them who might have a unlawful trespass charge, misdemeanor, disorderly conduct, or a driving with a suspended license, they're pretty sure, their attorneys are pretty sure there's no way they're going to be going to trial. So the incentive for them to resolve is not really there. But if you start saying, you know what? You have 10 driving with a suspended license, or you have 10 unlawful trespasses, guess what? We're going to be taking your case, we're going to take one of your cases to trial.
And that's been another change in strategy.
So we've tried to employ that strategy to bring in and say, okay, and what I have said to the judges is if you have somebody who has 10 or a number of cases, and each judge can get those reports and gets those reports to review if they are looking at them, they will see that if you have somebody with 10 or 15, you have the ability to say, okay, next Wednesday is jury draw. We're going to draw one of your cases, Mr. Smith. And if you settle that case, we're drawing your next case. And if you settle that case, we're drawing the next case, because the week after that, Tuesday, is your trial. And so by giving that a short trial date sometimes does have that impact.
And so in that case, you would be looking to have a sort of global resolution to all 10 produced by keeping the pressure on them with a trial date?
Statistically, that is what would happen.
Yeah.
But if that doesn't happen, that's okay, because I think we're also sending a message that we're going to get to your cases.
Yeah.
We're going to address the cases we need to address. But again, statistically, you're probably not going to have many situations where you have to knock off one at a time and try cases. Because if you try one case for a 3-month jury panel, can't try another case with that defendant during that panel. So if you have 20 cases, it would take a few years to go through all of them at that rate. But we don't see that happening much.
Oftentimes there are global settlements.
Yes, it's usually the case.
Great, well,
Just real quick, sorry. What's the lead time on going to trial? Like, you have a case that's open. Can you call them up and be like, hey, I need you here on today's Tuesday, I need you here on Thursday? Or is it?
Generally, we don't do that because of the preparation. That's not fair. Whether it's a civil case, let's use divorce for an example.
Yeah.
That's a place where people say, well, you should just call them in right away. If you've been waiting a year for a divorce trial involving children, and you got a call on a Monday saying your hearing is on Wednesday, that's quite disruptive to the parents. It's disruptive to the witnesses. It's disruptive to the kids who might be going from mom to dad in the middle of the trial, things like that, or mom, or people can't get there. So we try to, if you're going to have a hearing coming up, unless parties have said, we'll come in on short notice, and sometimes that happens, you try to give a month notice or so, at least 30 days or so.
So if you have like a 5-day period of trial days, you have 2 days, you get everything done that you wanted to. In those other 3 days there, do you try to reach out to people?
Sometimes you already have backups scheduled. So
Gotcha.
you have a docket in Rutland, for instance. We used to have a backup. We'd have trial days. What I said to Senator Baruth, I was sometimes panicking, going, okay, I promise I might not be able to deliver, because I know that those extra 3 days I've tried, I promised that I said we're going to try and let's pick a jury for those days. I know that we already have a full schedule each of those 3 days. And there were days you'd be sitting there going, okay, I hope that they either settle or, and there were times I go back to the clerk and say, well, we got to move that day. We have a trial coming in. So you try to give enough notice. There's generally things for backup. There's the ability to come and bring things in, but even if not, let's say that you had a day, that allows the judge an opportunity to take some time to work with staff to make findings, to actually do a deep dive into the data, to say, okay, now I've got actually a day where I had a trial. I can look at this and figure out which cases we're going to bring in next month and try to focus on. So it's found time for the court to take steps that might not otherwise have had the time for.
And oftentimes also you'll have emergencies coming in, emergency hearings that require immediate attention. So it's pretty good.
And I keep going back to Rutland because that's where I used to preside a lot. If you have, like Judge Corsone's, if that happens to him in the court, her husband, yes, related. If that happens in his court, and he has 2 days that he has to have a trial on, they'll bring in weight of the evidence hearings, or he'll help out another judge. in the county.
If it's
And do something.
or emergency juvenile, whatever.
I do want to thank you both for your time. I just want to make sure that we provide our next witnesses.
We just are giving these to the patient as community.
Oh, absolutely. Wouldn't take about those.
Thank you.
We can keep it pretty brief, but.
Yeah.
Well, we'll see you later this
Oh,
week. Thank you.
Yes, see you Thursday. Thank you.
Okay, great.
I also heard, Judge Gomez, that one of the contributing factors to the judges being almost that full was the ability and proficiency of that new judicial nominating.
I have been told the
Finding those
nominating,
well qualified individuals and passing them to the governor.
I have been told the nominating board has done a stellar job.
Very good.
So whoever, I don't know, whoever the committee on committee appointed, you must have done a
I
great job.
know. Just kudos to everybody.
I like that.
That's great.
Thank you both.
Thank you for everything.
And thank you for doing the confirmation series too. That was really fun.
Oh, yes, you're,
Oh, we're gonna take the other
most
one.
important meeting. There you go.
Yes, thanks.
That means Phil.
I was in another class, somebody claimed that the cookies that were there were better than Terry Porcelana's, and there was a general uprising. My idea.
Who is that, Mrs. Fields?
No problem.
Yeah, come on up.
Right, you speak this.
Right, so we are still live, Senate Judiciary. We have the ACLU here to introduce themselves and share some of their thoughts for the upcoming session. And it's Falco and I can't recall, Jordan. Okay, great. Yeah. So floor is yours. Feel free to talk.
All right, thank you so much, and thank you for the opportunity to testify this morning. For the record, my name is Falco Schilling.
My name is Jordan Souter.
And we'll do a quick introduction, background, our personal background, and then a little bit background around the ACLU, right, Civil Liberties Union, who we are, what we're working on, and some thoughts about the work of the Judiciary Committee for this year. So just so you all know me, my name is Falco Schilling. I'm the Advocacy Director here at the ACLU of Vermont. Born and raised in Saxons River, Vermont, and good old Wyndham County. And went to law school at Vermont Law School and have been with the ACLU for about 6 years at this point. You might see me looking quite tired in here at different points, including this morning. I'm the father of a 3-year-old and a 5-month-old, and that 5-month-old is really not like sleeping right now. I'll pass it over to Jordan, who's going to be covering a lot of the work of the Judiciary Committees this session.
Yes, like I said, my name is Jordan Souter. A little bit about me. I grew up in Virginia, also went to Vermont Law School, moved up there, fell in love with Vermont, and decided I wanted to stay here forever. Then I worked as a restorative practices facilitator at National High School North in New Hampshire. Following that, I then became the Youth and Community Program Coordinator at Orange County Restorative Justice Center. So I have a pretty decent background in restorative justice. I'm also very cold outside, but I'm really happy to be here. It's a pleasure to be able to be here with you all today.
Great. And so just a little bit of background about our organization. The ACLU of Vermont is one of 53 affiliates, the American Civil Liberties Union nationwide. We were founded in 1967, and for a majority of our history, I would say we were largely a volunteer organization. Attorneys here in the state who came together to take on cases that they felt were extremely important because of the impact on the civil rights and civil liberties of the people who call this state home. We are now an organization which will soon to be about 15 folks, and that includes 3 of us who are working on policy and advocacy issues and will be up in the building pretty regularly. Our third advocate, Alex Carapalis, will be joining us soon, but she's working remotely for a little while. She's going to be covering more issues related to housing, human services, things like that, whereas Jordan is going to be covering more of the work of the judiciary and corrections. And we also have 4 dedicated staff attorneys. And so within our organization, some of us are focused primarily in the policy space, working with you all up here on laws that are being crafted and policies within the administrative realm. And then we also have attorneys who are the ones who are bringing the cases in court, bringing lawsuits, filing, appeals, things like that. So we both have legal backgrounds, but neither of us have to go to court, which I really appreciate. And, we have approximately 15,000 members statewide. And the primary areas of our work include the criminal legal system, government accountability, including law enforcement, promoting voting rights, reproductive rights, right to housing, privacy rights. It's a pretty broad swath of things that we can be working on, because, the Constitution is pretty broad and implicates rights in a number of different areas. So we do our best to cover the work that's happening in this building. I think if there was even more of us, we could find pretty much something within every committee that we might be interested in. So we have to do the work, try to stay a little bit more focused. And part of the reason that we have been spending as much time as we do with good folks in judiciary committees is, when folks become involved in the criminal legal system, that has some of the opportunities to have the greatest impact on folks' rights, both victims and folks who are accused of crimes. And then our flagship campaign that we've been working on for the last couple of years is the Smart Justice campaign, and something that is part of a nationwide effort to try and push back against some of the increases in incarceration we've seen growing pretty steadily since the late 80s into the early 90s, and with a specific focus here in Vermont at trying to reduce that prison population from its peak, which we saw right around 2008. By approximately 50%. And when you look at the numbers here in Vermont, we have reduced it by approximately 35%, which is pretty impressive. And a lot of that has been done through the work of programs like Justice Reinvestment, with the Council of State Governments and others who looked at parts of our system and how they can be moving and functioning more efficiently. Most recently, that Justice Reinvestment work spent a lot of time with the Department of Corrections, and where they have discretion oversight of the folks who are on community supervision, especially the furlough program. So worked with folks in this committee on that, things like reinstituting earned time, and then also just general due process considerations for folks who are involved in that system. And then the other component of that smart justice work is looking at the disparities that exist within our criminal legal system, especially racial disparities, which is something that's pretty concerning when you look at the numbers here in Vermont. A Black person is approximately 8 times more likely to be incarcerated than a white person. If you look at the DOC data, and you see folks of Hispanic origin about 4.5 times more likely to be incarcerated. And then at the same time, we also know that there's large disparities in terms of folks who might have substance use disorder or a mental health condition. So those are, I think the Commissioner of the Department of Corrections testified to that last year. I think something like approximately 60% of folks within the facility on some sort of treatment for substance use disorder. I look back at the numbers, but there, and then a staggering number on multiple medications a day, especially related to mental health conditions. So I don't think that's surprising or unique to Vermont, that those are folks who get involved in the criminal legal system, but often try and advocate with folks outside of this committee, further upstream, for more supports and services to try and help folks before they get involved with the criminal legal system, and then creating effective off-ramps for treatment and accountability within the criminal legal system once folks do get involved. I think you'll hear us coming out a number of bills, and a number you have heard us talk about this before in terms of some of the approaches and to community safety and concerns about relying a little too heavily on increased penalties or extended time within prisons, just because research generally shows that tougher crimes don't act as a disincentive, or tougher sentences or tougher possibility of sentences don't usually act as a disincentive. More what we hear is that a swift resolution to these cases is what's more often a deterrent to folks. And also the concerns that longer times within prisons usually doesn't have the desired effect on recidivism that folks might hope, and sometimes can actually make that worse. So those are some of the perspectives that we often bring to the work that's happening within this committee. And I do think, just looking towards the year ahead, I think there will be some more unique conversations that might be happening as we, as a state, look to respond to some of the things that are happening with the new federal administration and some of the interplays that happen with either executive orders or other federal actions that might run contrary to existing state laws, and some of the interplay there. And as we look at what states can do to continue to protect the rights and liberties of the folks that call the state home. I think there's a greater concern around privacy, generally. So both personally held data and data that's held by state entities. How do we try and limit access to that, both to private entities that might use it for nefarious purposes, or also for government entities that might be looking for that for programs we consider, overreaching and against some of the values and stated laws that we have on the books here in Vermont. I think in terms of communities we see being potentially threatened, be folks like those in immigrant communities, folks in LGBTQ plus communities, especially trans folks, and also folks trying to access reproductive health care. So those are some of the communities that we'll be looking and talking with you all about. How do we continue to protect those folks, especially within our existing laws? And, I think we've had some conversations with senators already who are looking into some of these issues. So I look forward to coming in to be able to talk to you about a number of those issues, as well as your ongoing work within the judiciary. I think that's kind of high level around some of the work that we've been doing. Also one of our goals generally is to limit unnecessary police interactions. One of the concerns we have is roadside stops and the safety concerns that can be created there, both for officers and folks who are being stopped on the roadways. That's something that I know we're working with Senator Mahovsky on, and she's introduced a bill on that. I think that also comes to play with some of the concerns around immigration enforcement and how that plays out, things like our fair and partial policing policy, other things like that. So that's kind of a high level of our work. I don't have one particular bill I'm coming in here and saying this is what you need to pass this session, but do appreciate the really hard work that you all do. And just also very genuinely want to thank every one of you for serving here in this legislature. This democracy only works when people step up to serve, and it is not an easy job. And despite the fact that folks might have differences on policy, I genuinely really respect and want to thank everyone in this building for doing that work, because that's the only way that our democracy moves forward. So on that note, I just want to say thank you for the opportunity to speak to you, and happy to answer any questions folks might have.
Thank you. Any questions?
Falco, you had mentioned you had 15,000 members or
Yeah, members and
can you
supporters.
expand on that a little bit?
Yeah, so when we look at the list of folks that either receive our regular communications through our emails or are making donations, it's approximately 15,000 members across the state.
Okay, so I'm just confused when you said members, I'm thinking membership or whatever, so basically anybody who has received services or chooses to donate is considered.
Yeah, so often I would say members and supporters is probably a more accurate way to characterize that. There are folks that are in fact card carrying members of the ACLU.
Thinking about the American president, we said card carrying American citizens. I'm like, do we do that in Vermont? I don't know.
Well, technically, we don't issue the cards. So if you want to be a card carrying member of the ACLU, you got to give a donation to our national, and they'll send you one that you can keep in your wallet, which is often the thing that folks will show me, especially when they disagree with me. I will say often when I talk to folks, especially when in disagreements, they say, well, I'm a big supporter of the ACLU. And I think you guys got it wrong on this one. So there's a lot of agreement, and we work on a wide range of issues. And I think most folks can find something that we've done that they can agree with, and find stuff that they strongly disagree with. And I think that also exists within our staff, just because on the issues we work on are highly contentious. And that's usually when we get brought in there, where there's especially rights and liberties and tensions. I know in particular our work around free speech and free expression is a place where we could be working with folks that might not be the folks that other folks are working with all the time, but we really think those rights are extremely important, and abusing them in one area leads to abuse for one group of people, leads to abuse for other folks. So that's a place we'll find ourselves in tension with the folks that we might be more aligned on with some of our other criminal legal reform and things like that. And it can be a tough position at points, but trying our best to make it consistent and in line with our principles.
Senator Ruth.
I don't want to jump too far ahead because I know you'll testify on it, but when I sat down, I had the governor's omnibus public safety bill. Have you had a look at that yet? Do you have a sense of whether you might have concerns about it at this point?
I haven't fully dug into it, but I will say as soon as it came out, I got a number of phone calls from the media asking our general thoughts, and I was able to, speak largely just based on what I saw at the initial press conference. I do think that we will have some concerns around on that, especially as it relates to raise the age, which is something we think is important to move forward. And then I think as we look at some of the questions around bail, and some of the constitutional implications there, that's something that I think we need to dive in deeper on. Where is that interplay? What is permissible? And then just generally, when does it make sense to be pushing for more incarceration? One thing that is not usually what we are focused on primarily, but is something that is worth noting is the more incarceration does come with more costs. You had the Commissioner of Department of Corrections testify last week that our male facilities are at 130% of capacity. And that's why we're sending approximately 150 folks out of state to Mississippi. And for each one of those folks, that's $45,000 a year from the general fund. It's a little different than when you look at our in-state facilities where you have kind of more baked in costs. We got the buildings, we got the staffing. Those are all contracted positions. And through the Justice Reinvestment Initiative, all those savings, as we minimize the out-of-state bed usage, those savings can be reinvested in community supports and services further up in the stream. So that's something that we also think about as well. So, in terms of some of the bail statutes, I think that there should be some concerns there. Some concerns around trying to delay or repeal, raise the age. And I'm sure we're going to get into that quite a bit more. I know House Judiciary is going to be starting to talk a little bit more about that this afternoon. And then, we also just generally have concerns when there's attempts to increase penalties, which is something we talked to this committee quite a bit about last year.
Thank you.
Thank you. Any other questions?
I'm sure we'll have more opportunity to discuss those issues.
I'm sure we will. And sure we'll spend plenty of time together. But appreciate you having us in for the high level overview to start.
Absolutely. Well, yeah, thank you for coming in, and we can adjourn for the day.